Okay, so thanks again for joining us. This topic today is a repeat. This is a repeat topic for us. Something me and my partner George Hunter, who's also on the line with us, a lot of questions that we've gotten throughout our 20 years of being advisors. So a lot of topics that are near and dear to our clients that are very important and that come up. And so we're, lucky enough to have Edward Clay on the line with us as well. And so I'll introduce my partner, George Hunter. George is a CFP. He's been a financial advisor for over 20 years. George, why don't you say hey?
I just wanted to, have a good time here, and we want to try to answer these questions because we do come up against this often. We help people deal with estate planning issues before and after life events, and we just find it much easier to deal with the issues before life events, to help make sure that what a person wants to have passed along to the next generation, including their knowledge and their assets, in a way that is most cost effective, emotionally effective, and tax effective, so that we can pass these assets along. And sometimes we just get a referral over, and it's usually a lady with a box of stuff, and she may or may not have any idea of how to move forward. And we are at that point in time, we help her move forward with the least pain. But if we could have gotten to them sometimes a little earlier, it's very helpful. So with that in mind, we have Ed Clay on the line. He is an attorney in Maryland. He was admitted to the bar in 1989 and has experience in litigation, workers' comp, family law, and estate planning. But since 1995, he has spent his time exclusively on estate planning and practice. It's a charter member of the National Network of Estate Planning Attorneys. He's an adjunct professor of law. He teaches at the graduate level at University of Baltimore, and he's a longstanding girls softball umpire. So don't give him a hard time. He may throw you out the ballpark. He's told me about that a couple of times. So with that being said, we're going to be going over some emergency issues and try to avoid them in estate planning. So Ed, you're up.
George, maybe I should have worn my gear today. I don't know. So yeah, George mentioned something that's actually pretty poignant. The world would be great if, we didn't have to deal with things until they happened. Think about it. If we didn't have to buy car insurance until we were actually in an accident. Oh, I'm in an accident. Now let me go buy insurance to let them cover that. And unfortunately, the world doesn't work that way. And so the more prepared you are for circumstances, the better the result usually is. So today we're just going to talk about what really affects those emergencies that we call them planning emergencies, or emergencies in the estate plan. So I'm going to share my screen, and we have a PowerPoint, and we're going to go through things. And by all means, if you have a question or concern, please shout it out. And it is a small group, so I don't think it's going to cost us any particular length of time. And if you are talking about something that I will be bringing up, then I will just say, hey, can you just wait a moment? And then I'll come back and circle back and say, hey, this is what we're going to be doing. Let me see, a little bit later, and we'll go from there. So this is, where am I? I don't have the right screen in front of me.
We see a good screen.
You see the correct one, but I don't see the correct one. So,
okay.
So now I have the right screen up. So, and the technical issues were on my machine, so it's my fault that that we were late coming on. So I will take full responsibility for that. So we're calling back estate planning 911, what to do or what happens in an estate emergency. Our brand of estate planning is called Family Legacy. And the reason is because we make sure that your family is properly addressed and that your legacy is properly preserved. The estate plan works, and that we have a process designed to do so. And it's not simply driving through the drive-through window, ordering a document and maybe getting fries and a Coke with it. It's something a bit different than that. This is who we are. We're located based in Lutherville. We meet clients all over the state, more or less in person. We meet in Rockville and Bel Air, and I can cajole in a little bit in Port Deposit up in Cecil County, but we can meet by Zoom anywhere in the state of Maryland. And if people are outside the state of Maryland and they want to come into the state of Maryland, we can work with them as well. But that's our contact information. If there's ever any concern about who we are, what you heard, you can certainly follow up with either Wade or George, or you can follow up with our firm directly in any one of those ways listed. So what is an estate emergency? It's not a trick question. I think it's pretty obvious that an estate emergency we would think is death. All right, so it's the end of our existence here on Earth, and disability. And when we mean disability, we're not talking complete incompetence. So yeah, it's an easy call. So I have a stroke and I'm unconscious. So I'm in the ICU. Yeah, that's incompetent right there. So you're not able to respond. That's the easy one. The harder one is when it's simply just an interference with decision-making skills. We are otherwise functional, but for something we just can't keep up. And that is very, very common in today's world. It may progress to a nursing home level of care needed, but it doesn't start that way. And so that is something that we always want to consider, is that there's a potential that we could be there. And I don't think there's anybody in the United States right now who doesn't think that there is a possibility that they will outlive their ability to function. So there's if you listen to companies that sell long-term care insurance, they will tell you you're 6 times more likely to experience a period of disability before death. And that's probably true. It's probably even greater than that these days. We just don't know, because there's all kinds of things that affect us: our diet, the environmental exposures that we have to whatever varying levels of chemicals in the world. We just don't know all these factors that come in, and they could over time, or it could be just old age. My mother-in-law is almost 94 years old. She can't do the finances anymore, even though she did them all her life. But now she has to have help doing that. But she can stay at home. She lives at home and does her thing. She just can't do the money anymore. So you can actually do financial harm to yourself when you are somewhat disabled, but not incompetent. And so there's a disparity there in the way we approach that. And it's not necessarily that severe dementia or things like that. It's just, we just lose our focus over time. So why are they emergencies? Well, because people own property. And in reality, ownership after death would need to be transferred to the right people in a legal process that is recognized and is assuredly legal enough to be transferring ownership. But then there's also the situation where someone needs to oversee and manage property for you during a disability, and not necessarily be ones who will take it and use it for their own purposes. When we find those kinds of things, we take them and send them to the police department and have people prosecuted for doing that. That's a crime. You can't do those kinds of things. We're talking about someone who is doing things for the right reason and taking care of you. Those are the two issues that are the estate emergencies. So if we believe Mr. Stephen Covey, he wrote a book called 7 Habits of Highly Successful People. I think it's Highly Effective People, and I misstated the title, but be that as it may, one of his habits is to begin with the end in mind. And so we're all on this road, a road of life. We don't see the end, right? So it's somewhere ahead of us down the road, and so, but we know it's going to be coming up. And so, do we want to be prepared for that in that circumstance? So what happens to property at death? Well, I'm a lawyer. And so as a lawyer, I'm taught to say, it depends, right? So it could be this, it could be that, it could be another thing. But I will tell you this, it depends on how the property was owned at your death. So it is the titling of your property. So our first lesson is, what you own and how you own it are the driving forces in estate settlement after your death. Okay, it's not your paper that you buy from your lawyer. It's what you own and how you own it that it either coordinates with the paperwork that your attorney did or it doesn't. So you either are coordinated or you're uncoordinated, one of the two. So the title is what yields the result. So how it's owned is going to determine it. So you could own things in a way that scuttles your estate plan that you went to the lawyer to purchase. So it's important to make sure that your estate planning includes an analysis of how your property will pass based on its title and whether there are recommendations to retitle the assets to make the plan control what happens at your death. So that's a connection that is lost because the legal profession sells documents. So there's my knock against lawyers in general, even though I am one. Sometimes I'm not happy with my tribe, and this is one of those areas. So what title? What do I mean when I'm talking about title? Well, we can own property individually in our own name. We could own it individually with a beneficiary attached to the property. We could own jointly with another person, but those joint ownership aspects are individuals. So that's different because our next one is joint with another person with survivorship rights. So that's where we own property jointly. And as the joint owners start to pass away, the remaining survivor wins. They get the entire property. So it's called survivorship. It's an automatic title change. Contractual ownership. Think life insurance, annuities, IRAs, those kinds of things. And trust ownership. So those 6 main ways that people own property. And so each one has its own issues. So they're treated differently at death. And sometimes what seems easy to set up has ripple effects in other ways. So you need to know what happens to these types of titling when you're deciding to do them. So the problem that I see is that the knee jerk is like, oh, this is going to be really easy for passing ownership. Okay, well, what is it going to do in the meantime? And how does it deal with issues practical and tax-wise? So practical, we can have issues with particular beneficiaries, and tax-wise, we could actually accelerate a tax that we could otherwise delay by simply titling it in a way that's really convenient and easy to pass at my death. So my point is, it's like a balloon. You squeeze one end of the balloon, the other side of the balloon pops up, gets bigger. Everything is connected in some way. There's a connection in different ways, but we often look at these things in isolation when we're making decisions. I think it's important that you be aware of all of the ripples before you go in and decide how things should be titled. Individually owned property. Okay, that's that downward arrow that we saw. That is controlled by a will at your death, if you have one. So if you look at recent surveys from January of this year, it's 32%. I have a slide coming up that's going to say 32% of Americans have a will in place. So if you don't have a will in place and you own individually owned property, then you're relying on the state law to determine where things pass. And maybe it matches what you want, maybe it doesn't. But who knows what that law says? I do, but very few people do if you're not a lawyer, because you don't want to look at the law. Who wants to read the law? So individually owned property has to be administered through the probate process. That is a process that's overseen by what's in Maryland is called the Orphans Court. It can also be called the probate court, but traditionally it's been called the Orphans Court. Why? Because back in the time when the state was first settled, it was a court to take care of widows and orphans. So that's why it was called the Orphans Court.
Can I jump in real quick, just from an operational standpoint?
Knock yourself out, George.
Yeah, thanks. So when something like this happens and somebody dies and they come to us, and this happened a couple months ago where an individual came to us and his brother died and they owned property, and now what? How do you pay the taxes? How do you get access to the information? How do you get access to the mortgage? All these things, you really, you're at the short end of the stick here. So this, if you don't have a plan around this, can be a very, very difficult place to be.
So,
Right.
so when you plan, that's the key word is plan. So when you're going through and and you go through all these different types of ways of passing ownership of property, and George brings up a really good point. Because what often gets left to the individual name will be things that are illiquid. And your money accounts have designated beneficiaries, and they go passing those beneficiaries. And then you have this property here that may have a mortgage. You may have land that may have a mortgage on it. It certainly has property taxes, but there's no money to pay those, because the only thing in the estate is this. And so that creates a plan that fails. But I doubt that people want to have this property foreclosed upon and sold, or sold for taxes. If you've ever had to get a property out of the tax sale, you know how expensive it would be. And, from time to time, we come across estates where we have to do just that. And the extra money you have to pay to get it out of the tax sale to the person who bought the property. You have a right to buy it out, but they make a profit off of that transaction. So yeah, it's important to make sure that things are coordinated. And that's the overarching message, is to coordinate. I don't care what your strategy is, whether you want a will, you want a trust, or you want whatever. Just make sure that everything is coordinated. So the process includes inventorying and valuing of assets, claims, debts, and administration costs paid. And the other thing to think about that just occurred to me, and I didn't intend to include it here because it's a little bit going down a rabbit hole. But I just want to let you know, tidbit out there, this nugget, that if you die and you do have a mortgage, and your property passes to a family member after your death, the mortgage company can't come in and force the full payment of the mortgage. If they continue to make the payments that you set up, then the mortgage company has to take the payments and just move along. They can't come in and say, oh, so Jim died, so now Jim's family has to pay off this note. No, there's federal law prevents that from happening. One of my favorite things to do is to stick it to the lender and tell them that there's this federal law and you need to walk that back and go. So I love doing that. So if you know anybody who has an estate like that, send them to me, because that's a fun thing for me to do. I really enjoy it. And I know it's a perverse enjoyment, but it's one of those things that we do as a lawyer. Sometimes it makes it work. But the process after in a probate is there's this period of time where claims are made or potentially made, debts are paid, and any administration costs are paid. And then you have to provide an accounting to the court to be approved. And once they approve it, you're able to distribute the estate. The problem that the biggest problem I see about probate is that it is a public record. So not only does your personal information, not your social security number or things like that, but I'm talking about your asset information gets published. Your beneficiaries' names and addresses get published. All of that is available for anyone to look at. You can do it online. If you know somebody who's died and you know what county in which they lived, you can go to that county's Register of Wills website in Maryland, and you can plug in their name on the estate search, and then it'll find it, and you can download their estate documents. You can download a copy of their will. You can do all that. All that becomes public record upon death. And that's the thing that I think is the most unfortunate aspect, but it keeps with the First Amendment principle that it's an open system, and that it's the open system that polices the integrity of the system. So the reason why you're allowed to go in and sit on any court case is that the public has a right to make sure that things are being conducted fairly. So that's why you have a right to go and sit in on any trial, except in very, very limited circumstances. And I mean very, very limited circumstances. And this is the same principle. So it's a public record because the principle is that the public will police it to make sure that everything is going okay. You can expect about a 9-month to 12-month administration period on a regular estate. And attorney's fees are limited to 9% of the first $20,000 of assets, and then 3.6% of the rest of the assets. So 9% of $20,000 is $1,800, and then 3.6%. That's the upper limit. Anything beyond that we have to petition the court and give a reason why we're exceeding that amount. And it would have to be approved by the court. So what if there's a beneficiary designation? So we can add a beneficiary to our accounts and make sure that things don't pass through probate. And so what'll happen is it's a convenience. And these are things that you might have seen: payable on death, POD, transfer on death, TOD. And with real estate, we use something called a life estate deed. Basically, Maryland doesn't have anything called a beneficiary deed, but other states do. But the life estate deed functions that way. So you're just saying, okay, at my death, it's going to pass directly to this individual that I've named in this deed. Now, the titling takes priority over your estate planning documents. So these titling, when you title this way, it passes directly to the individual. It does not pass according to the terms of your will. It just passes to this individual owner. So the beneficiary gets it immediately upon your death, once they present the death certificate and photo ID. So they have to prove that you're dead, and they have to prove where they are. So it passes outside of probate. So there's none of that public record stuff. Some concerns that I have, the ripple effects. A wrong beneficiary can be named. One of the ways that we see wrong beneficiaries being named is when there is somebody who is benefiting from a means-tested disability benefit. They are named as a beneficiary on one of these accounts. If you're doing that, if you know somebody that has that and they're named as a beneficiary on one of your accounts, you are screwing them over royally. So if you have that situation, you want to address that right away, because you're going to put them through hell once you die of trying to scramble to not have their benefits disrupted. They have to create a special trust to hold these assets. They have to have that trust approved by the state agency that oversees disability. And that all has to be done within 30 days of your death. So you have this real short window to do all this stuff. It's a technical document. There's few lawyers who do it. And you can really run into problems with people. And you see that people do this when they say, oh, I'm trying to help this person because they have a disability. They're going to need money to fund their disability. No, 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 no. You have to make sure that you understand what you're doing. There are many other ways to do this planning and provide a source of funds for them to tap into without interfering into and this is one way, and I'm harping on it because I just experienced it in February of this year, where it was several $100,000 of assets, and this individual and their kids are all on Medicaid because they had young kids, and they have a disability. And think about this: the disability doesn't mean that you're bedridden or anything like that. This person was not able to work because of a medical condition that they have, and so they have. I'm not going to talk about what it was, but they could otherwise function, but they have this medical condition that doesn't allow them to work. So this was all proven, and they were the wrong beneficiary for that. So be careful about those things. And also, Maryland has something called an inheritance tax. And if you leave the inheritance tax, or leave something subject to inheritance tax, that's a 10% tax. And for property passing outside of probate, it is a 90-day limit for payment of that tax. And so if we were to name a person who is subject to this tax, so we have no kids of our own, we name a niece or a nephew as one of our beneficiary for our house, but we're not leaving them cash, then they have 90 days to come up with the cash. That's 10% of the value of that property. Whether or not they're able to sell in 90 days and get it all done, who knows? But that's something to consider. Probate assets have until the probate is finished to pay the inheritance tax. So that could potentially be delayed. And that's one reason why you might consider using probate as a means of passing, as opposed to this real convenient way of automatically changing title. If the beneficiary doesn't realize that they owe this tax, and they go beyond the 90 days, and then somewhere down the road, a lawyer advises them that 2 years later that they need to pay this tax, and they go back to pay the tax, penalties and interest are going to be assessed. So just make sure that we're not doing things that we didn't intend to do. There's no other attorney's fee other than the cost of creating the deed. So this is very attractive to folks who are very allergic to writing checks to attorneys. And that's probably the most common refrain, is that you don't have to pay. What about joint ownership with another person? Well, owning jointly, recall this tenants in common. So I might own 50% and someone else owns 50% of this property or this account, and we own as tenants in common. That means my 50% is my 50%, and it's treated just like individually owned property. So everybody owns their portion, and it does not pass to the surviving co-owner automatically. It passes just like the individually owned property, and a probate is required to legally transfer ownership of this type of joint ownership. So the attorney's fees are the same limitation, depending on the value of the assets. Another way of owning property jointly. Question? Another way of owning property jointly is with survivorship rights. So with survivorship rights, it's commonly known as joint tenants with right of survivorship, or you'll see the notation on, if you have this in one of your accounts, it's titled this way, you'll see JTWROS sometimes. And that's just the acronym joint tenants with right of survivorship. And what that simply means is that the survivor wins. Everyone owns a share of the entire property, and title passes automatically to the surviving co-owners, and whoever is the last survivor gets the entire property. There is no probate involved. One of the issues comes in is a potential capital gains tax that you might not otherwise have to pay. And that's specifically when somebody adds somebody else's name to their house or their account, under the thought that, oh, now it's not going to be subject to nursing home spend down or anything like that, because there's this co-owner. And that is a mistaken thought. But what you've done in that situation is you potentially, if that is the person who's ultimately you want to benefit from that property or that account, if there is a capital gains assessed, so let's say it's a house, we add their house. Let's say I paid $100,000 for my house, and my house is now worth $1 million. So that's a $900,000 capital gain. If I add somebody else to my property, I'm giving them my cost basis along with that. So when they measure the sale price, they're going to measure from their cost basis. And on a gift, it's going to be the same one that I had. And you're potentially creating a large capital gains tax after your death. If you pass that property after your death to that individual instead of gifting it during your lifetime, then their basis becomes whatever the value was on the date of your death. And that creates a smaller gain if they go to sell your property. So there would be a smaller tax to them. But the convenience that this provides portends to have a potential tax consequence. So that would be one of the unintended consequences that would come about this. But the other one is that co-owner liabilities can attach to the value of these accounts. Your co-owner gets sued, then the judgment creditor can clean out your account, because by its nature, the joint ownership account, either owner can liquidate the account. And if the judgment debtor can liquidate the account, the judgment creditor can. So be aware that when you add somebody else's name, you add their potential liabilities to your account as well. And if you're okay with that, hey, great. But just make sure that you're aware. And then there's still the inheritance tax issue. The inheritance tax, if you're trying to do this to avoid inheritance tax, there's a 2-year window where it's automatically deemed to be pulled back into the deceased person's ownership, and for tax purposes, and the tax is assessed on the full value of the account. And we still have that wrong co-owner thing that we talked about previously, especially if the person doesn't know that they are attached to this account. And how can that happen? Well, it's easy. If you do a deed, you can add somebody else's name. In fact, I have one on my my desk. This was somebody presented this to me back in May. They didn't know that their name was on the deed, and yet they had technically owned the property for 5 years before mom died. And so there's all kinds of ways that you can name the wrong people and you can create problems. So just make sure that you understand that you ask the questions and that somebody's there to explain it to you. No attorney's fees are associated with this other than drafting a deed if you want to do that. And we routinely talk people out of it because there's better ways of transferring ownership in a cleaner way than it is to do the joint tenancy with right of survivorship. Contractual ownership is what we normally think about as life insurance. Life insurance has some really great potentials to help our people, but also has some unintended consequences as well. There's no inheritance tax if it's paid to an individual. It doesn't matter who it is. So I said earlier, as an example, the nieces and nephews would be subject to inheritance tax. Well, not if they receive life insurance. So the life insurance industry was really good about carving out this exception to the Maryland inheritance tax. So the insurance lobby, and this has been there forever. I've been practicing for 35 years. The entire time that I've been practicing, this has been the law. And decades before it was the law before I was alive. So I mean, it's always been around, and so it's very good in that regard. Now, what you don't think about is that the value of the death benefit is also considered your asset when tallying up the assets you owned at your death, so in your estate. So I own $1 million life insurance policy. Now, I don't have $1 million to spend during my lifetime because it's a life insurance policy. It pays off at my death. But the federal government says, okay, you own that policy and that insured your life. So therefore, it's that death benefit that paid out was your asset at the time of your death. So you artificially inflate when you own property, own a life insurance policy that it inflates your estate with assets you don't get to spend during your lifetime. So that's there, and you got to be cognizant of that and where you fall. These days, with the estate tax exemption being so high that it becomes less and less of an issue. In 2026, the estate tax, federal estate tax exemption is scheduled to drop automatically. And so it will become more relevant to more people at that time. It's January 1 of 2026, unless Congress acts between now and then. An annuity is a gussied up insurance policy. So think of it like an insurance policy that actually gives you a benefit during your lifetime. So that's kind of how we explain it to our clients. It's a little bit more complicated than that, but I think that's probably a good working way to view it. So annuities are a type of insurance. They're usually produced by insurance companies. And it's just that life insurance doesn't usually pay you a direct benefit, but annuities do. So that's the way to look at it, I think. But those are contractual with the company, and retirement accounts are as well. So we lump them because these are all beneficiary designation assets. So we don't do a whole heck of a lot with them, but we do have death beneficiaries that we appoint. So remember, the retirement accounts are for tax deferral after death, and until your death. And then we want to make sure that we can defer tax as much as we possibly can. We have the same issues here with wrong beneficiaries. So that's a recurring theme. So it doesn't matter what you do. If you're taking the easy way out, you've got to, and just saying, I want to designate these people as automatically getting, make sure that these people, A, don't have an issue that they're dealing with now, or B, have the potential to have these issues down the road. So the inheritance tax does apply to annuities and retirement plans, but like we said, if it's paid to individuals, there is no inheritance tax on the life insurance.
Let me jump in real quick on the beneficiary thing. I think that before and after any life event, you really need to go through all of your contracts and things that have beneficiaries, IRAs, Roths, insurance contracts, to verify that they are proper and they're going to the right people before and after there's a death. And we've seen
or divorce.
Or divorce,
Yeah.
or divorce.
Right.
Correct. Or a new marriage.
Right.
things like that. It's consistent that that we see issues. And it's way easier to get a
George,
document. Go ahead.
That's another reason. So I'm gonna jump on this because while I have it in my mind, that's another reason why you never leave your retirement benefits in the 401k with your former employer. You move it to your own IRA with folks like George and Wade, because they're going to be poking you in the ribs to say, you got to fix this. When it sits in that that retirement plan with a former employer, they don't care. They're not gonna come at you and say, hey, you want to make sure you update your beneficiaries. They don't care. They're using your money to generate more money for the retirement plan, and you don't own that account. All right, the employer owns the account. You participate in that account. If you move it to an IRA, then you own the account, and you got guys looking out over your back to make sure that you're getting things done, and that's how you hedge against the beneficiary issue. And believe me, when people are afraid, they're penny wise and pound foolish, they're afraid to hire a financial advisor to help them remove funds that way. That's where we see 50 years later, there's no change in the beneficiary designation. So, it's really, and that's not an exaggeration, because yeah, I've seen 50 years of beneficiary was named and it wasn't changed, and somebody died 50 years later. And it was just absolutely bizarre that nobody would even think about looking at it. But it's so easy to overlook because it happens all the time. And the way you do that, the way you help yourself, is to have those accounts move to your own accounts and not stay with the employer. And I'll tell you what, we hate it when we settle estates and we're trying to get these retirement accounts moved over to the beneficiaries. You know what happens? They say, here's the forms you have to fill out, and everybody has to sign them and send them in. And then 3 months later, you say, well, what's going on? Oh, we're working on it. We're getting there. And then another 3 months goes by, and you say, okay, what's happening? We need you to sign this paperwork and do that. We never got this paperwork. And so you do it again. And that's what happens when you're dealing with 401k accounts after somebody dies. And just get it out of there and get it over to your financial advisor and make sure that that is something that's going to not create angst for your people. And we had, in the last 10 years, we had one account that took 2.5 years of lather, rinse, repeat, submitting the same junk over and over and over again, frustrating the beneficiaries. And they saw the emails, we saw the emails, but that's the consequence of leaving in a 401k.
Right.
So
You can't trade or do anything on the account either till it's titled right.
So attorney's fees, it all depends. There might not be a whole heck of a lot to do in there, but you never know. Revocable trust, very common for people to select this in recent years. So if you want to use the word trendy, it's become a much more trendy. And there's a couple of reasons for that. So the trust doesn't require probate. There is an administrative period because there is a period where claims can be made against your trust after your death. So just to get that out there. Beneficiaries have to be notified. They can request a copy of the trust. They also they can request a yearly accounting by the trustee. This happens after your death. So when you create your trust, you do whatever you want to do. But if you have a trust and you pass away, this is what happens. The administrative period is not a public period. The public does not get access to your trust. Only the beneficiaries can. If you do happen to name a wrongful beneficiary, if your trust is drafted properly, you can actually cure that. There's a way to cure it. So it's possible that you could be in a position to fix it at your trust level, as opposed to forcing that beneficiary to scramble in that 30-day period after your death. Inheritance tax technically applies within 90 days, but your trustee can post a $100 bond, and they'll extend it to whenever the length of time it is that you're ready to pay. that if you can get it extended to before the beneficiaries receive, as long as you pay the inheritance tax beforehand. So it's technically a non-probate asset, but you can post as bond, and it's, like I said, it's $100, and it simply says to the register of wills that you'll get your inheritance tax before we pay out to the beneficiaries, but we're going to deduct the expenses that are associated with administering the trust. There is usually cash in the trust to pay, because it's important to have all of your assets titled in your trust to make your trust work. Attorney's fees, they should fall anywhere between 1/3 to 2/3 of what the probate would be. So it's routine in our practice to charge as little as 1% as a ceiling. And in fact, what we try to do is we try to say, if your people come to us and they come through our training for their be a trustee once every 5 years, then you get a 25% reduction on the fees, because it makes our life easier in the long run to not have to deal with so much after your death. And if we can streamline that, then we can actually make it easier and less expensive to pay. So you compare the 3.6% on the probate versus the 1%, and we think it becomes a good deal. It's up to individuals. The other aspect about trust that deal with disability, and that's where the trust separates itself from the other strategies. And if your trust is like a lockbox, think of it that way. You get to decide when you're considered disabled. So you get to decide what is the triggering mechanism in your trust to when you're considered disabled. All right. So who would be in charge if you are considered disabled? And what do you want them to do? How do you want them to spend your money? Do you want them to take care of maintaining your household so that you're able to live in your house as long as possible during your disability? Do you want them to spend your money on widening doorways if you're wheelchair bound, putting a ramp, getting a handicapped bathroom, get a bathtub with a door on it so that you can walk in instead of step over? Those kinds of things, all of these things, countertops lowered, all that. So do you want to do these kinds of things? This is what we see is missing out of most estate plans, because even when people employ trusts, they do not talk about these things. What they do is they just rely on what all the other ownership types rely upon, is we have this power of attorney. I'm putting somebody else in my shoes so that they can go and do things. I'm not telling them what to do. They can just do whatever they want to do and what they think is important. I'm not leaving any instructions. The power of attorney is an enabling legal document. It does not include what your wishes are for how you want them to spend your money. So one of the biggest defects in estate plans is that we have this likelihood that we're going to go through a disability, but we don't take the steps that we want to. And why don't we take that? Because lawyers don't say, hey, there's a possibility you can do these kinds of things. Do you want to do this? All right. Everybody says, where do you want your stuff to go when you die? Let's put this in. Who do you want to be in charge of these kinds of things? And it's not done. This is your first warning that it's available to you. And that's what I see as the biggest hole in estate plans, is dealing with instructions for what happens when you are disabled. Different plan comparisons. So one can be changed at any time while you're alive and well, and so can the other. One must be approved by the probate court after death. The other doesn't. One takes effect only at death. One takes effect when the document is signed. One does not require asset retitling, because if you own all your assets individually, that's where it will pass. The other, in order to work, requires asset retitling. There is less control at disability, for one, but there's more control potential at disability with the other. It's generally less costly to create one. The other is a little bit more expensive, and because there's a greater time investment to do it right and to deal with all issues. But the fees for the less expensive one to create is usually more expensive to administer, but the other fits for the right goals. Uncertainty versus certainty, and a will-based estate plan is the one on the left, and a revocable trust-based estate plan is the one on the right. So for the normal estate, it becomes a much, if the values or if the goals align, the revocable trust becomes more valuable, or if they don't, then the will-based plan is more valuable. It doesn't matter to me what my clients choose, as long as the goals that they state they have match with the particular plan and how things can get done. So if you have a very, very important, it's very important to you to make sure that disability is under control and the control that you want under your instructions, well, then you're going to steer away from the will-based plan and you're going to look at a trust-based plan, because the trust strategy provides you with the opportunity to be much more specific in disability than does a will-based plan. The one thing to remember is that elder law issues are not addressed in those two plans that we were talking about there. So the nursing home issue is a separate issue, and it has to do with the rules related to how those benefits are paid out. Suffice it to say, if you are reactive and you're got 1 foot in a nursing home and 1 foot on a banana peel, you're going to be in a lesser position, lesser ability to effectively protect assets. If you're early on and you're realizing that something isn't quite right, and you get diagnosed with early onset dementia, well, that's the time to take advantage of it, and you'll be able to save potentially a lot more. This involves irrevocable trusts, not revocable trust. And so it has to be done in a particular way for a particular purpose, with the calculations made out so that you get exactly what you're looking for. You're getting maximum protection with minimum cost and qualification for the benefits. And you can do this. Even if you have 1 foot in a nursing home and 1 foot on a banana peel, you're in the worst possible circumstance. We could still protect about 45% of your assets. So that percentage goes up exponentially the earlier on you are in the process. So this is something different than what we talked about before, but I wanted to just introduce that concept so that you don't go away thinking that, oh, this trust, when I talk about disability, it does not protect. Revocable trust does not protect. Irrevocable trust will. But we'll talk specifically. One of the problems that, again, the legal industry has done is said, if you have a will, you can check the box. If you have a power of attorney, you check the box. If you have a advance directive, you have to check the box. But the problem is the way these are done is through renting the lawyer's word processor. I recently found one of these, it was actually revocable trust that was done, where it had the variables where the trustees' names were supposed to be. That's where the lawyer had the trust already on their word processor, and they were supposed to cross out the names or cross out the variables and plug in their names of the individuals. And so many lawyers use forms and plug your name in the forms. And so we think it's important. You have to find an attorney that does document assembly through software. There's software available to lawyers that they can customize it and do however they want to do it, but so that it'll assemble an estate plan for each individual client based on their particular goals. It's not rocket science. It's just computer science. So don't be Pavlovian and think that you have something, because a lot of times it becomes a placebo effect. 32% of Americans have will prepared for them. That's a survey from 2024, January of 2024. In 2020, that same figure was 46%. In 2020. So it's dropped in the last 4 years. But 64% believe that a will is important. Young adults were the only demographic group that did not decline in the percentage. So something's going on with baby boomers and the like. So when we hear the words, I need a will or you need a will, the question is, what are we saying? That, we know we're going to die. Are we really saying that I need to execute a legal document that will determine where individually held assets at my death will transfer after my assets are first publicly listed in a court file and in a process called probate easily challenges my wishes? And it's a similar if you need a will. Or am I really saying I know I'm going to die someday, so I want to get my affairs in order so that my assets pass efficiently to my beneficiaries while controlling cost and conflict. When you go to a document jockey, you're going to get that first one. You're going to get the I need to execute a legal document that a will determine where my individual assets will go after publicly, because you say to somebody, I need a will, and they take you literally, and they're not being an attorney, they're being a scribe. They're saying, you've made a conclusion on your own, and I'm just going to help you execute that conclusion. And instead of asking you, is that what you really want to do? So in essence, what's happening in reality for most folks is that they're on the expressway of life and they hope that they take the right exit. When they do take the exit, they hope it's the right one. And there's very little going on in terms of goal orientation. So understanding what the result you want to achieve is important for the lawyer. And then that way we can decide what is the best strategy to get you there. So most everybody has watched the Fixer Upper show. So I use this all the time for goal to get people focused on goals. So Fixer Upper is all about the goal. Joanna shows this laptop screen to the folks and said, look, this is what your house is going to look like when we're all finished. And they say, yes, that's exactly what we want. But nobody asked Chip, hey, Chip, what's the difference between a Sawzall and a grinder? And which one are you going to use, and how are you going to, which one should you use, and this and that. Nobody talks about his tools. But the first thing that we ever get asked is about our tools, wills, trusts, and those kinds of things. But it's the vision, understanding what the goals are for folks, understanding what they want to see happen. We have to learn that before we say, okay, this is what this tool does to get you there, or this may not be the best one. This may be based on what you've told us. This one over here may be better. So you don't need tools unless you have a goal, but so often everybody wants a tool, but don't want to talk about goals. And so it needs to make it work, because if you know your goals, the tools will sort themselves out. Does it matter? Well, nothing matters unless it really matters. And it's what you learn after you know it all that counts, because you don't know what you don't know. And in case you weren't aware of it, that was the autobiography of Earl Weaver, the longtime Orioles manager. He wrote a book called It's What You Learn After You Know It All That Counts. So, did you know that in your estate plan, you can determine when you're considered disabled? Did you know that in your estate plan, you can determine who should be in control of your financial affairs when you're disabled? And did you know that in your estate plan, you can determine what they should do when you're disabled? You have the ability to take the bull by the horns and be proactive and include that in your plan. And did you also know that in your estate plan, you can leave an inheritance protected against future lawsuits against any beneficiary, protected against disinheriting your kids if you happen to be married, if your spouse passes before you, protected against potential Medicaid spend down for the beneficiary, and protected against that beneficiary's potential divorce. So this is why we always start with an orientation to understand what these are. The orientation gives you a good basis, it fuels your awareness, and most of all, puts you in a position to make good decisions about your estate plan. We do these on a regular basis, usually the third Thursdays. In July, we're not doing them in July, but our next one is August 15th. We do them via Zoom at 7 p.m. and at noon on the third Thursday of each month. If you're interested in more, Wade and George can help. You can also go to estateplan.org, our website, and check it out if you're interested. I thank you for your attention. There's a lot of things in a short period of time coming at you, but I thank you for taking the time to listen and to be here today. Hopefully you found value in the session, and I'm happy to take any questions, concerns, or anything else today.
Does anybody have any questions? Anything on the top of their mind? Awesome. Well, know that Wade and I are also available at any time if you have any questions about your situation, you want any guidance or help, we're happy to do that. We're licensed.
I think Benjamin has a question.
Okay.
Yeah, George, I just wanted to comment that I thought this was really excellent.
Awesome.
Very clear. I was hoping that somehow you could supply the slide presentation. You know, I took some notes, but my notes are not as good as the slides that you used to
Yeah,
explain
we'll be
the
happy
basic
to provide
elements.
those to you.
Yeah, we can
Well,
we can
Yeah,
provide.
we'll share the ones with my picture on it.
Ha!
Yeah,
Awesome.
well, that's even great. So we
That's
remember
No,
who
you're
did
fine.
the
We'll
presentation.
get those, Benjamin. We'll get those over to George and Wade and this afternoon, and then they'll be able to.
Also, George, I was thinking about some other people I know who would really benefit from this video. Is the video like rerun? Is it available for others to see?
It will be. We're going to go through our compliance to make sure we can get up online. Hopefully within a week or so, we're going to have it up.
Yeah, it'll be a YouTube video is where it'll end up. We'll have a link to it.
Terrific. That would be great.
Worst case scenario is we can post it on our website and then provide that information.
Yeah, so when also if it all falls through, we actually have a similar one of these on our website. But we want you to go through George and Wade to drive the business in that direction. But if it falls through and there's some kind of snag at the compliance, then we have an alternative. We have a backup for you.
I can beat the compliance up on this one. So.
Also, I had a question as to whether you have an existing video or something that answers some of the questions on protecting assets in terms of if a spouse needs to go into a nursing home at some point, do you have to spend down all your assets with the nursing home institution, or is there some way that you can have maintain some of your assets for family at the same time the spouse is in a nursing home at government expense?
So yeah, that's probably a separate topic for later, another event. But I will answer your question directly. The answer is yes. There are ways to pass property without spending it all down. So if you were to ask the state of Maryland as to what you would do, you call the state Medicaid agency, they'll say, oh, spend all your assets until you have $2,500 and then come back to us and we'll give you money. And when people do that, they get disheartened about it. And so I'll give you a recent example. We had a widow who was in a nursing home, and their family was paying $14,000 a month is what they were paying. And the lady's house was sold, and whatever was in her bank was about $400,000. So she's already in a nursing home. They're already paying that out, and we were able to save around $190,000 of the 400. And so the answer is yeah. And then with spouses, you can even save greater amounts. So that the law gives you more than 2,500 that you are allowed to keep when there's a spouse. And so it's a mathematical calculation that has to be done on an individual basis to give you accurate numbers. But the takeaway, Benjamin, is that yes, there are ways to preserve assets in much greater numbers than you are maybe led to believe out in the world. So there's a lot of rules, and if somebody learns one of the rules and they tell you one of the rules, they may be correct in the rule they're citing, but they may not be correct in how it applies. So the rule is you have to have $2,500, no more than $2,500 in your name to qualify for those benefits. And that's true. We can help you with your estate to get you to that $2,500 in the state's eyes without spending all of your assets. So you don't have to spend everything to get to that point. You just have to know where the safe harbors are. And that's what we do. We help folks in that regard. So hopefully that helps you. And if you have fears that you shouldn't do things out of fear, but it's too easy. We can scare the hell out of people and get them to do things. I prefer not to be that way. But you have the opportunity to set up your estate so that you have protections. The more proactive you are, the more effective you'll be. But suffice it to say, there are, and we can, we're pretty accurate in our projections, so we know the law. And if we were to sit down with an individual and they gave us all the information we needed, we would be able to calculate exactly how the effect was, the numbers we would be able to protect, and we would be really, really, really close. In fact, we tend to overstate. And we've had in recent times when we've applied for Medicaid benefits, the result was actually more beneficial than we had projected when the state approved the benefit. So you can certainly do that. It's very effective to do that, but it's not the normal way, because it deals with giving up control of some of your assets, and we just tell you how you can give up control with a purpose in mind. And so that would be, I think that's probably a separate one. And there's no video because the numbers change. So I could run through the numbers as they currently are, but in January they're going to change. So they change, and putting a video up means that you got to constantly redo the video over and over again. So those are usually live events that we would do. And so if George and Wade are interested in redoing, we can certainly come back with that particular edge.
Hey, Ed, Angela has a
So
question. Oh, sorry, go ahead, Ben.
I just mentioned something. About 25 years ago, there was a couple I'm aware of where the recommendation was to pauperize the wife who was most likely in need of nursing home care. And so the home, which was jointly owned by the couple, they removed the ownership of the wife to the husband, and this is in New York State, and I believe it preserved the home for the use of the husband and the family, even though the wife was in a nursing home at government expense. Does that make sense as a strategy to pauperize, meaning removing assets from the person who is in need of care for their disability?
Yeah, Benjamin, that's important because they are the applicant. So the applicant, in order to qualify, the applicant must not own assets. So the first step when there's a couple is we transfer assets from the sick spouse into the well spouse's name. That's the first step. That's easy. There's no penalties for doing that, transferring ownership. But yeah, that is a first step, and it is that gets them qualified, because if we remove assets so that they own less than 2,500, then boom, they qualify financially. So and by transferring to the spouse who is not sick, that gets you there. There's more to it than that, but that gets that one part solved. So yeah, it is right. And that is something that we do as a first step.
Good, thank you very much.
But I would suggest don't do this at home, because there are other things, there's ripple effects that you could cause, and that we know some shortcuts and some ways to make it more effective. And the one thing that everybody overlooks in that area is, and I don't want to go too far down the rabbit hole, but what happens when the spouse who is not sick suddenly dies? That's the one thing you got to consider as well. So there are ways of addressing that, but you got to do it the right way. Angela has a question about the living will. I noticed that physicians sometimes ask the question to make sure medical directive is not ambiguous from a medical point of view. Can you advise on this briefly? What is the threshold that someone needs a trust versus a simple will based on your goals, Angela? We do a goal assessment. You tell us what kind of issues are important to you. Our experience is that when people describe the way they want things to happen, they describe as a practical matter how a trust works. And the notion of a simple will is I don't want to pay a large attorney's fee, and I get that. We scale for people who are modest, real modest means, and they describe a notion of a trust. We will provide a modest fee. So we do address that that concern, but we find that most people will like this. They'll describe how a trust works and then say we want to call it a simple will, and that really means that we don't want to pay a large attorney's fee, and I get that. And so we work through that. But your goals are what's going to drive you. And so that's why we ask about goals, and we say these goals are solved this way. These goals can be solved any number of ways, and you make the decision as to how you want to proceed. And as far as the medical, physicians sometimes ask the question to make sure your medical directive is not ambiguous from a medical point of view. The medical directive is based on the statute, so we use a statutory form for that, and the language is taken directly out of the statute, state law. So it shouldn't be ambiguous. Because, and the reason is because there's medical input, and there's all kinds of input into that language. And the reason we use that format is because it is most common and it is easily recognized by the medical providers. I'm not sure exactly what you're referencing in medical directives. So maybe you can elaborate exactly what you're talking about. You're muted, so make sure you're unmuted.
Okay, thank you. I'm really enjoying this state planning session, and thank you so much for doing this for us. It's just needed by so many people. I'm not really quite sure. I just had two physicians actually ask me that question. I guess I should ask more questions about what they're referring to. But I guess when it comes to what is considered a person being in vegetative state versus not, I think that's what they were mainly referring to. How would that be?
So the actual provision says a persistent vegetative state, and what it means. So there is actually a definition to it. If it's done properly, it has a definition for what it is. But you're exactly right. The persistent vegetative state is what that Terry Schiavo
Yes.
situation was, and Terry Schiavo. If Beth, if you're the same Beth that was on the last one this morning, she heard me say this morning that Terry Schiavo was 25 years old when all that went down. So when she had that brain injury. And so when you're 25, you don't think anything about that kind of stuff. And then everything gets jumped into the legal profession. And so it winds up judges making decisions about those things. So yeah, I can see where that could be potentially appoint an individual. But the state law provides a definition for it. When in doubt, your healthcare agent makes the decision as to
Okay.
what's going on. So you're pointing somebody to make those calls. What you're saying is that if I'm in this situation, this is how I would like you to tend to me. And if that individual isn't sure, then they're probably going to err on the side of caution. And if a doctor isn't sure, then you may stay connected to machines a little bit longer than you expect. But it's I don't know that I don't see a lot of that at all. My personal experience has been that they'll come to you and say, "There's nothing we can do to change the situation. She's not going to get better." And you tell us what you want to do. You're the agent, and so then the agent makes that decision. And if the agent's comfortable that they're being told the correct medical advice, they may act on it based on what your directions are in your medical directives. So hopefully that's helpful. I'm not sure.
Okay, thank you.
But this-
And
can
my
you
third
address-
question was, could you please address, I don't know, complications that arise when someone leaves a person as executor when they're not a family member?
There's not really, it depends on the individual. One of the things that we try to do is well, when we ask you about who should play what role in your estate plan, and then you have to tell me why. Not because I'm going to evaluate your answer, but because I want to know, why did you select that individual? What about that individual makes them the right person? So whether they're a family member or not, I would suggest that it doesn't matter whether they're a family member, because sometimes if a family member feels that they should be selected and another family member is selected in place of them, you get the same issues that you would have with a non-family member coming in. What I think is important is to get everybody an idea about how the process works after you pass away. So that anyone who is named as executor or a backup or anyone as a beneficiary, that they know in advance about how the process works, so that when the process does happen and it happens the way they've been told, that takes away the stress, that takes away the doubts. When somebody finds out in that moment of crisis that things aren't as they expected it to be, that's what ratchets up the stress. That's what creates the animosity and the potential complications. And it's strictly, and I'll tell you this is, again, this is my experience, getting in front of this at the outset and saying, you're here because you're playing this kind of a role for Angela. All right, so let me teach about what these roles mean and what the responsibilities are. Likewise, you're a beneficiary of one of our clients. And so we're going to teach you about what it means to be a beneficiary. And this is how the process will work. This is what's going to happen. This is what has to happen before you ever receive anything. This is all, knowing that stuff in advance is something that bridges any issues that pop up. They usually bridge every issue. We get better results with settling estates after someone passes away in cases where we've been able to proactively reach out and teach. We have a classroom in our building, so I don't know where everybody is located because I don't know that. But in our building here in Lutherville, we have a classroom that seats 24 people in a classroom setting, and I teach groups of clients, family members. So it's not teaching them what you have and what you're giving them and those kinds of things. It's teaching about how the process works. They get to see other client family members when they're here. They get to experience the group learning dynamic. They get to experience someone else asking a question that they might not have thought about. And then when they hear the question, hey, that's a good question. I want to hear the answer to that. And everybody goes away with a better understanding about how things will play out during a crisis. Because during the crisis is the worst time to learn. Because you're a stranger in a strange land and you have self-doubt about what's going on. And what am I going to do? Are they going to do the right thing? If you know it ahead of time, or it's been explained ahead of time, and then it's confirmed later on down the road, then you're going to be in a much better position.
And you just hit on a good point right there about that, because what I was really referring to, let's say someone surprises you and leaves you as executor, and you didn't know, but you're not a family member. That's mainly what I was referring to.
Oh,
Okay.
that's
Okay,
dirty.
that's a whole different ball of wax.
That's dirty. You must really not like that person if you're going to set them up that way. That
And
puts
you
them
hope they would talk to you first, but sometimes they don't. But they might hint around at it. And
Did
so
you have that happen to you? Is that why you?
yes. I
Okay.
have a friend of, well, really two people who are friends of my parents. My parents passed away and they're elderly now, but they have children. And they sort of hinted around the fact that they might rather leave me executor of their estate because they don't really feel their children well, they say a lot of different
Competent.
about their kids.
Well, they don't trust. Yeah, they don't
Not
trust.
responsible, or they
Okay.
don't trust, but maybe they're not responsible enough. and they know me well all my life and notice how I handled my mother's and my grandparents' estate. I don't really want the responsibility, but they're like really family to me. And I'm like, oh my God, is that what they're gonna do? And anyway, that's a whole other ball of wax right there.
Yes.
Yeah, Angela, that's you know, it's great to be liked, but sometimes it's not so great to be liked, and that may be one of those situations. Now, look, if you get along with everybody, um,
And you don't even know their kids.
you don't know them.
No, I
Okay.
met them once. But we're not
Well, let me
in the same
here's,
state.
here's the other question I had. Do they live in Maryland?
No,
Okay.
one lives in Tennessee, this family, and the other one in Texas.
Well, you know, I would tell you point blank to say I can't do it.
Now, they haven't said they would, they're just thinking about it. And I'm like, oh my
Yeah.
God.
You tell them that as a practical matter, with you being in Maryland, that's not going to work. They want to get somebody local.
They don't want to talk to me about it. They just says, well, you're in my will. And so I'm just letting you know I might leave you. I
And,
might
you,
have
and so, Angela, you have the last word. You have the last word on it. So you get to say, I don't want to do it.
Right. Okay. I'm gonna call both of them up and try to get some more information.
I guess it also depends how much is in the will.
So that
Because I'll tell you why, because you're not going to be able to use estate funds to travel back and forth. You're going to have to front that. And then
that's another question I wanted to ask.
you're going to have to seek reimbursement from a court to approve reimbursement to you.
Now,
And so in Maryland, they would say, well, you know, that comes out of your that just comes out of your commissions that you're allowed under state law, but the commissions are shared with the lawyer. And so that when the numbers that I gave about attorney's fees, that's really a shared limit between lawyers and personal representatives or executors. So you got to be careful about that because you might not have enough room to be reimbursed for that. So I think anytime you have something, especially, you know, look, I thought you were going to say they're in Virginia or DC or something like that because they're just across the border. You can certainly get an attorney to help you and deal with things. But I think definitely in Tennessee or Texas, you would have to have an attorney involved. But I think it just complicates the logistical complications are high because, you know, we've had situations. We had a famous, I say famous, it's an infamous case here in Baltimore County where a daughter left her mom, her 91-year-old mother, on the toilet for 2 days. And the mom died of renal failure. And she was charged with manslaughter. The other daughter was the executor, but she lived in Indiana. And so she had to keep driving to Baltimore for because we had orphans court hearings and things that we had to get through. She had to come back and forth all the time. And that's a 10-hour drive from Indianapolis to Baltimore. And so that was doable, but it was taxing on her. Now, Tennessee ain't a 10-hour drive.
no, I had my mom's estate, I'm sorry, in Tennessee for 2 years and I had to commute constantly.
Yeah.
But the state attorney wrote in the division as me as executor that I would be paid out of the estate. And so I got a.
But you know, everybody assumes you would be paid out of the estate. However,
To handle her affairs.
Yeah, I know. And so you got to be careful about each state in each individual state. So, we jumped through that. You know, we're spending a lot of time on that, and I'm not sure if the recording is going to.
Yeah.
Oh, okay.
So why don't we take that offline, Angie?
Okay. All right.
About that.
Okay.
Angela, sorry.
Thank you. Okay.
Cool. So I think this is about time to wrap this up. If you guys have any questions, any specific issues, feel free to reach out. We can make sure everybody connects with everybody. I think it was a great call. Thank you, Ed, for your time. And thanks everybody for participating. Wade, do you have anything?
No, I think you were touched on. I don't know if you got to it. We're licensed in all the states. So, you know, Ed is in Maryland, but I know some of you that are on the call here in other states, you know, just come to George and I, and we'll make sure, you know, you get the help you need.
Yeah, and we have connections in all states, so we can make referrals to attorneys
Awesome.
in Tennessee and Texas. So.
All right. Thanks, guys. Thanks, everybody. Thank
Yeah.
you.
Thanks.
Yeah.
Guys.
Have a good
Terrific.
afternoon.
All right. Good
Yeah.
afternoon. See you, Jim.